I'd like to move into the area of technology in the courtrooms, 21st century and everything. And I had some experience with this myself. I was preparing for a Vioxx trial, and this was a couple of years ago. I know if you, Judge Stack tried the first Vioxx case in Illinois, and this was about 3 years ago, and it was the first time that I implemented a PowerPoint with animation. And we had researched whether or not I was going to be able to use that in front of the court. It was in front of Judge Carol Higbee in Atlantic City. And she allowed us to do it. And in this particular case, because it was a pharmaceutical case involving Vioxx, which caused a thrombotic event, which caused blood clots, and showing the jury how that occurred through animation was extraordinary. And the jury commented on this. And so I don't see that happening in asbestos litigation. And I was wondering if you could talk a little bit about what's going on in your courtrooms, and the lawyers could talk about whether or not they think this type of technology would be useful.
And I have an additional question on that to the panel, which has to do with the disclosure of any PowerPoint slides or evidence that you want to show to the jury, to the other side before it's done, and whether, what is the prevailing view on whether that is necessary, advisable, and how do you do it in a way where you're not giving the other side your case before you present it to the jury?
Lisa, are you talking about an opening statement or witness by witness, or both?
Well, both, but
Okay.
Start with opening statement.
I have an absolutely inflexible rule that every exhibit that you intend to offer in evidence be marked in exchange in advance of the trial, with the exception that if it's truly impeachment, you may reserve it at risk of having it excluded. I've never run into a problem. It does not include your opening statement, because I tell you that you're going to make an opening statement and you're ethically obliged to have a good faith belief that everything's going to get in that you say and show in your opening statement. And if you don't, I'll fix you. And I have not had a problem with that either, although I've had a lot of really nervous lawyers say, I got to see the opening statement, I got to see the opening statement. And it's never been a problem.
You mean opposition lawyers?
Yeah, the opposition wants to see it, and I say if they want to show it to you, they can, but they don't have to.
I let them. I ask them. I don't force them to exchange, but I tell them that I would strongly encourage them to exchange. But I should tell you, if you use technology in my courthouse, there are vehemently different views, and this is in your openings, of whether the judges will let you. This issue came up at a bench bar conference, and I was absolutely astonished at the venom that went back and forth between the judges on my court in front of all the lawyers, because they felt very strongly. I happen to like technology. I think some of the most effective openings I've ever seen have been done in technology. In fact, at one point, a juror raised her hand. I thought she needed to use the restroom, and I stopped and asked her what it was, and she said, could you please tell him to roll that back? I really want to see that again. And I had to give the charge again that this is not evidence. But there are judges in Philadelphia that will not let you, under any circumstances, use technology in an opening.
Well, I think the original question wasn't about openings, but I'll address openings because I have seen several trials recently where opening statements were done in PowerPoint, and the other side took the PowerPoint opening statement and used it against the other opposing counsel throughout the trial. And it happened to some very good lawyers. One of them, John knows, from Chicago. And Manny even said to me, he said, I think I made a mistake. That's the first time I ever used a PowerPoint. But with regards to your use of that type of
Technology.
Technology.
Animation.
Animation. I go back to the rule about if it assists the jury. And certainly when you watch something on the Discovery Channel, it assists when they do those animated portrayals. And so if it's going to assist the jury, and as long as the other side has had an opportunity to see it and to make their objections to it, or to be able to come in with their own animation, then I think it's fair. But they have to be allowed to see it first and make their objections.
I agree with that.